Good morning, everyone, and welcome to New Jersey's Gaming Law, what every employer needs to know. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today are Mike Collins, Patrick Doran, and Jessica Pearl of Archer. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. I'd also like to draw your attention to the questions tab. Mike, Patrick, and Jessica would be happy to take all of your questions, so don't hesitate to write them in as they come to you, and I can't stress that enough. Write them in as they come to you, or you may forget what you wanted to know by the time we hit the Q&A. So now let's get things started. Patrick?
Thank you, Vinny. My name is Patrick Doran. I'm a member of Archer's Labor and Employment Department. We have what we hope to be an informative and entertaining presentation for you today. Before we dig into the details, just to go over our agenda, while our presentation is focused on what employers need to know and should know about legalized sports gaming, we're going to start with a little background and explain how we got here and where we are in terms of what the law is. After we do that, we'll turn to some more specific focus on what considerations employers need to be aware of in an era where we have legalized sports gaming in New Jersey and increasingly throughout the nation. In the midst of that presentation, we will have some specific focus on particular items of concern for healthcare employers, but we will address the concerns that really are applicable to any employer in this environment. So we'll turn it over to Mike Collins, who's going to address the law and how we got to an era of legalized gaming in New Jersey and elsewhere. Mike?
All right. Thanks so much, Patrick. So the timing of this presentation seems fairly apropos because just last week the gaming numbers were released by the New Jersey Division of Gaming Enforcement, and it really shows that sports betting is a blossoming industry in the state. Just last Friday, they said that $184 million were bet just in the month of September alone, which is a drastic increase from the month prior in August, which had $96 million bet. And overall, just since mid-June when sports betting was legalized, $336 million have been bet. This is certainly a boon to the state tax coffers as well, as the state realizes about 8% of the total amount that is won by the books, and so the state will be taking in drastic amounts of revenue as part of the legalization. And these numbers are very comparable to what Nevada already takes in, and that's obviously a very mature industry as it pertains to sports betting. So as Patrick mentioned, we're going to start out with a brief overview on how sports betting became legal. It seems like for decades, no one has been able to legally place a sports bet east of the Mississippi, and the only way you could is to have a bookie or go on some sketchy website. And now all of a sudden we see advertisements all over the state and people betting on their sports on their smartphones, and it seems like that just seemed to happen overnight. And that's because of a lot of litigation that occurred in court over the past few years. So here's a little overview on all of that just to feed some curiosity. The federal sports betting ban that prevented New Jersey from having sports betting in recent years was adopted in 1992. It was called the Professional and Amateur Sports Protection Act, commonly referred to as PASPA. And this act banned states from legalizing sports betting unless they were grandfathered in at that point in time. And Delaware, Oregon, and Montana had limited sports betting, which they got to keep. And as everyone knows, Nevada had robust sports betting, and they continued to maintain that from 1992 till the present. Interestingly, the law also gave New Jersey an opt-in period at that time if they wanted to legalize sports betting, but the legislature didn't adopt a constitutional amendment question to do so, and so New Jersey lost that opt-in in 1993. Oops. We're going to fast forward now from 1993 to 2011. And obviously public opinion had changed over that time regarding sports betting, and also Atlantic City was beginning to suffer some market force pressure based upon gaming opening up in neighboring states. So at that point, New Jersey wanted to boost the gaming industry and also the equine industry at the racetracks, and the legislature authorized a ballot question to legalize sports betting both at Atlantic City casinos and licensed racetracks. This question went to the voters, and it passed with 63.9% of the vote. Okay, I think we got it to advance there. Fast forward to 2012, after the referendum passed, New Jersey enacted what was called the Sports Wagering Law, and predictably it allowed casinos and racetracks to have sports books and to take bets from patrons 21 years of age or older. And the betting was to be regulated by the Division of Gaming Enforcement, the Casino Control Commission, and the Racing Commission. In my past life, I was an attorney in the governor's office and had the privilege of working with many of those regulators, and they certainly were well positioned at that point in time and are well positioned now to regulate the wagering that would be going on at the casinos and the racetracks, and the legislature kept that framework in place when it passed the 2012 law. After that law passed, many people took action expecting that sports betting would be legal in New Jersey. And one case that's been cited at Monmouth Park, the operators there elected to move ahead and build the William Hill Race and Sports Book at a cost of approximately $2 million. And so they were moving ahead with sports betting once this law passed. But later on in 2012, the sports leagues and the NCAA filed a federal lawsuit against New Jersey to block implementation of the sports wagering law and, in effect, to stop Monmouth Park from opening up a sports book, arguing it violated PASPA, which was the federal law we referenced earlier. In turn, New Jersey and Monmouth Park argued that the law, the federal ban, was unconstitutional. Under PASPA, it was illegal for a state to legalize sports betting. So the law said a state could not sponsor, operate, advertise, promote, license, or authorize by law sports betting. A lot of legal terms there. The real question that the courts had to deal with was whether or not that ban on legalizing sports betting was a legal exercise of the Congress's Commerce Clause powers, which it obviously possesses, or, as New Jersey and Monmouth Park argued in response, that the federal ban, quote, commandeered the states. And commandeering is a term that is specific to the 10th Amendment, and kind of going back to a history class or civics, the 10th Amendment is the amendment that says that all powers that are not reserved to the federal government under the Constitution belong to the states. So without getting into the specifics of each court filing, this is just a chart of all the litigation that took place debating whether or not the sports betting ban was constitutional or not. It went through 6 years of litigation. The red is where New Jersey lost. The green is where New Jersey won. And so New Jersey did a lot of losing as part of this litigation. And the hits,
so much losing.
Yes, but now they're winning. The hits just kept on coming. And on the left, you saw that in district court, New Jersey lost. They took it up to the Court of Appeals where they lost. New Jersey asked the Supreme Court to take the case. The Supreme Court said no. New Jersey's legislature then turned around and followed the guidance of the Court of Appeals, which basically said you can't kind of legalize it, but you can kind of decriminalize it. And so they passed what was called a partial repeal, basically a workaround of the sports betting ban. And the legislature overwhelmingly adopted it, 28-1 in the Senate, 73-4 in the Assembly. You just don't see these margins on very many things. So the legislature quickly acted and adopted that. And immediately the leagues took the state back to court. New Jersey lost at the district court level. They lost again at the Court of Appeals level. They did have the benefit of asking for the entire Court of Appeals to rehear the case en banc, which they agreed to, but then they ruled against New Jersey. And then in this case, the U.S. Supreme Court said, we'll take the case. And just this past May, they found for New Jersey. So New Jersey got that win that they were hoping for all along after 6 long years. And just to hone in on what exactly the Supreme Court held, they said that the federal ban, PASPA, was unconstitutional and it violated the 10th Amendment anti-commandeering doctrine. So like I mentioned earlier, the 10th Amendment protects the states from the federal government exerting any powers that are not otherwise afforded to it in the federal Constitution. And it also is premised upon political accountability. And that whole theory is that the New Jersey legislature and the voters in New Jersey said, we want sports betting. They all voted to set up the regulatory regime to have it. And then at the end of the day, it was really the law from Congress that was preventing them from following their desires. So the anti-commandeering doctrine is to basically prevent Congress from requiring the legislature to do things it doesn't want to do. And then finally, it's also forcing New Jersey to pay the bill for banning sports betting while Congress is able to kind of skate free by passing the statute. So in sum, all of a sudden, by the stroke of a pen, the U.S. Supreme Court issues this decision, and the states were then free to go ahead as they wished as it pertained to sports betting. New Jersey was obviously one of the states at the forefront of wanting to legalize, and on June 11th, 2018, passed the new sports wagering law, 37-0 in the Senate, 73-0 in the Assembly, and quickly enough, it was signed into law, and just like that, that's how sports betting became legal. So it really was a tortured legal history, a lot of legal nuance, but just because between the Supreme Court decision and the legislature's action, now all of a sudden we went from absolutely no sports betting to you see sports betting on your phones. So now we're going to talk about the law in New Jersey and who it prevents from wagering on sports, and then that'll tie into our following presenters, and they're going to speak about the specifics that are of importance to employers and the like. Under the current New Jersey statute, it is prohibited to wager on collegiate events that occur in New Jersey or that involve New Jersey teams. This is a protection that was in the state constitutional amendment legalizing sports wagering. So clearly the legislature felt that if we're going to go down the route of having sports betting, we don't want wagering on Rutgers or Seton Hall, for example. So that can't occur in a bet that's through a New Jersey book.
Mike, how does that translate to the professional teams in New Jersey?
Well, it's interesting. The professional teams in New Jersey also have a clause in the Constitution regarding games that are played at home but not necessarily on the road. But then there's a question of whether or not how that applies to parlays and other bets that might involve that game, but not just that game, one side or the other, but tied in with other games. So that's really a question that is more statutory and to the regulators. But it was definitely a concern of the legislature in general that they don't want things that occur on our own New Jersey turf to have the taint of, what people say are the sins of sports betting, possible games being thrown in that nature. So they were trying to prevent against that. And ultimately, I think those are questions that the legislature will have to grapple with moving forward as we see sports betting become more pronounced. High school events are also banned as well as some others. Fantasy sports is actually separately regulated by the Department of Law and Public Safety, which is the Attorney General's office. So the New Jersey law does prohibit certain people from casting sports bets. Very broadly speaking, it has certain limitations upon athletes, coaches, and referees, as well as owners of professional teams. It certainly restricts members of sports governing bodies. So if you work for one of the leagues, you're out. Or broadly, it restricts anyone in a position of influence or authority over players. I certainly think that term will have some interpretation to be had in the future. And also anyone with access to exclusive information, but that ties into the sports governing body based upon publicly available information. So that's talking about someone, again, who works for the leagues or for a team, not necessarily someone walking down the street who just heard some information about a potential injury on a player that could really affect the outcome of the game. If you happen to fall into kind of these loose categories that are contained in the New Jersey law, it's a disorderly person's offense. It carries a fine of between $500 and $1,000. One other body of regulation to take into account are the NCAA regulations. The NCAA has certainly over the past decades been very outspoken about being against sports wagering, and their regulations reflect that. They prevent student athletes and any staff members from wagering on any sports contests or for providing any information to individuals associating with sports wagering activities. And the sanctions are pretty sharp for student athletes. If they do something that would affect the outcome of a game or doing some point shaving, the so-called death penalty. They're no longer eligible for life for the NCAA. And if you just participate in it, there's a minimum 1-year ineligibility. So NCAA certainly has regulations that affect its member schools. And there's certainly a rationale that the NCAA exhibits in trying to protect the integrity of their games and prevent people from profiting from inside information. But the NCAA is obviously just one entity, and there are many other entities that will, cross paths with people who have a role in, whether it's collegiate athletics or professional athletics. And so that ties into the remainder of our presentation, specifically how employers should consider all this legalization on sports gambling. And so for that, I'll turn it back over to Patrick.
Thanks, Mike. So we've learned a little bit about what we got here. Why should employers care? And in the first instance, employers should care about this whether or not gambling is legal. And I think we're going to talk about some examples of how gambling already has been a workplace issue. But specifically, in terms of the now legal environment for sports wagering, the American Gaming Association has estimated that approximately $100 to $150 billion of sports wagering has been occurring illegally in the past. Now, when you look at New Jersey's total in a very early month, almost $200 million in September, as Mike explained, you can see where just in New Jersey you could have several $billion wagered even in the first year of legalized sports wagering in the state. And New Jersey is currently one of 7 states where wagering is legal. I just saw that yesterday New Mexico became the 7th state to have legalized sports wagering at 2 locations. In addition to New Jersey and Nevada, of course, we also have Delaware, Montana, West Virginia, Mississippi, and Oregon. And by the end of 2018, we're likely to be talking about Pennsylvania, New York, Connecticut, and Rhode Island also offering legalized sports wagering. And there have been some estimates that half of the states in the nation by 2022 should offer legalized sports wagering. Now, of the $184 million that were wagered on sports in New Jersey in September, well over half of that, $105 million, almost 60% of it, was wagered online. And I would hazard a guess that a large part of that was wagered on people's smartphones. And before we got started here today, I live in Pennsylvania, so I don't have access to this. Mike was showing me just how easy it is on one of the apps, the FanDuel application, which operator is that associated with, Mike?
There's quite a few. FanDuel, I believe, is through Meadowlands, and basically each operator has their own app now, and it's worthwhile for people to kind of explore as the market expands what the market will bring. So
there are already multiple smartphone applications by which people in New Jersey can place a legal sports bet, and again, well over half of the total in September was wagered in that manner. And it's to the point where, and we talked about this, somebody at the Eagles-Giants game last week could be sitting in the stadium and wagering real time on bets on changing lines during the course of the game. So there's no question we're talking about a massive industry in its very nascent days, at least in the state and throughout the nation. The DraftKings app, which is, I think, in conjunction with Resorts, is already doing 53,000 unique bets per day, which is 300% higher than what their own projections anticipated when this became legal. I'm sure we've all seen or been exposed to the litany of ads. I don't think you can turn on the radio without hearing an ad for one of the sports wagering applications or sites. I was on the beach this summer and saw a plain banner ad for the Borgata Sportsbook, which was closely trailed by another plain ad for the hotline for gaming addictions, which I thought was interesting. But as it pertains to employers, here's the question. Does anybody believe that of the 105 million wagered online in the month of September, that none of that was wagered by people who were on the clock at work? And of course, there are no statistics to prove that, but I think all of us and the clients that we've worked with over the years, just in their experience with things like March Madness and fantasy sports, and we can talk about that a little later, I think it is very safe to assume that a significant portion of that $105 million wagered in New Jersey by people in the state was wagered by people who were on the clock working at the time. Likewise, does anyone really believe that of whatever amount was wagered at work, that none of it was wagered using devices owned by employers or on systems that are controlled by employers, websites, computers, et cetera. And it wasn't that long ago that employers were focused on developing policies. Well, how do we manage use of the internet for personal purposes? And that cow got out of the barn, and I think, I'm not aware of any employers that have policies that prescribe any non-business use of the internet for most of their employees. And I think we're going to see a similar explosion in people using online gaming services, either on their work phones or actually sitting at their desks. And this is something that employers need to be focused on. Simply in terms of productivity, a massive time drag for employees. And you think about this, fantasy sports is one thing. The rabbit hole employees could go down researching wagers on an infinite host of potential wagering opportunities is massive. And when Mike was showing me the FanDuel Sports app this morning, an hour ago, there were live bets available on tennis matches being played as we speak in Australia.
And you have to figure you could probably stream the game on your phone as well if you have the right app for that.
Absolutely. So simply from a perspective of productivity, it's something that employers need to be focused on, because we're now well beyond the fantasy football team or the March Madness pool. We are literally talking about a 365-day, 24-hour-a-day opportunity for people who are interested in this to be pursuing it, not just placing wagers, but doing research about which wagers they should place. Beyond productivity, morale concerns, and we all sort of can think of the camaraderie that things like March Madness pools can generate in offices. But the flip side of that is there can be very negative impacts on employee morale in the workforce. A supervisor who lost a wager could have some ill will towards people. People that are in a fantasy league together and one wins and the other does not could have some ill will towards each other. So something that may not be of an immediate concern as productivity is, again, something when you consider this environment where people can be doing this virtually any time, is something employers should be focused on. And then, of course, legality is its own separate issue. Now, just because sports wagering is legal, do not necessarily assume that that means all form of related activity is also legal. One of the questions left open, and there's been some debate about this, which we won't need to talk about today, but under that Supreme Court decision, the Murphy decision, is whether the Wire Act still applies to some aspects of what the states now believe is legalized sports wagering. And for example, the Wire Act applies not just to bets, but information relating to bets and the transmission of both bets and related information through interstate commerce. And again, we don't need to belabor this, but there are people who are debating whether or not there is still an argument that some forms of interstate commerce and the transmission of bets or information could be illegal under the Wire Act. Beyond that, and we'll touch on this in a little bit, I think it is very likely that there will become more laws. Mike touched on the law related to inside information as it pertains to governing bodies, but I think experience internationally is likely to bring us to a place where you start seeing legislators considering laws which prohibit anyone from wagering based on inside information. And we'll talk about that as well. And that certainly would be a consideration for employers that we're going to talk about in some more detail. And inside information. Imagine a scenario where a front desk hotel employee overhears that LeBron James broke his hand in Game 3 of the NBA Finals and makes a fortune wagering on the Golden State Warriors for the remainder of the NBA Finals. And that becomes some public knowledge. Now, whether or not that employee's wager was illegal and whether or not the employer would face specific legal consequences for that, I think we would all agree that that would potentially be an embarrassing situation publicity-wise for that employer, where there is some expectation that employees in that business are exercising discretion and not necessarily utilizing information that they overhear or in a position to access by virtue of what they're doing while they're on the clock. You could have a situation, where this results in loss of business for the league. Let's say that hotel has a contract with the NBA, where the road teams, when they're in that market, stay at that hotel. And again, you could have a situation where beyond those public relations and business considerations, I think it is reasonably anticipated that down the road, there could be specific legal liabilities, not only in terms of laws that might address that sort of wagering, but also, is it really hard to fathom in a litigious society such as ours, a situation where a legal sports book thinks about pursuing some legal action against an employer in that sort of scandal? Is it likely? Hard to say. Is it impossible? I think hardly. Legal bookmakers have the greatest incentive and the greatest sensitivity to any irregularities in wagering markets. The house is now legal. Their profits and their licenses are on the line with this stuff. And again, I don't think it is a far stretch to imagine, in the right circumstance, a sports book which lost a lot of money based on a wager placed with inside information to pursue any and all possible defendants to address that sort of situation, even if they do not believe that it's likely to result in a judgment, at a minimum to send a message that this is not something that's going to be tolerated.
And I would note there have been cases like that in the past. So if the regulators decide that if you have certain information, you can't place that bet, the way New Jersey's laws are structured, and the same is the case in many other gaming jurisdictions, if a bet is illegal, it's invalid as a matter of public policy. So there have been cases with casinos in Atlantic City saying that a bet wasn't properly placed because of certain things that had occurred, and that immediately negated any of the win, and that person owed as restitution back to the casino that amount of money. So that certainly, if those people, whether it's from a legal standpoint or a policy standpoint, it could very well become public through litigation, and really also a PR issue with people following the litigation.
So what types of information are we talking about? Well, one obvious one is the health of an athlete, of a participant. I mentioned the LeBron James example, and Jessica in a few minutes is going to talk about some more particular issues relating to healthcare providers and employers in that space. Participant availability generally, in terms of an athlete who may be resting in a certain game. This has become increasingly prevalent, specifically in the NBA, where star athletes are rested for purposes unrelated to injuries. Lineup decisions, again, if there's some information that a manager of a team is going to change the lineup in advance of the game, or with respect to tactics. There's other examples. Let's talk about the mental or emotional condition of an athlete. There could be a situation where you could bet in a golf tournament after the world's #1 ranked golfer was embroiled in a scandal where he crashes his car into a tree. Or a more mundane example, the college quarterback, the first-string quarterback at a top 10 powerhouse, breaks up with his girlfriend on Thursday before Saturday game. Field conditions, and there's actually been an example, which we'll talk about in a minute, of an athlete getting paid to give field condition information to a bookmaker. Referee assignments. It's interesting to note in Major League Baseball, for example, umpire assignments for the week are released to clubs on Monday, but they're not disclosed to the public until hours before the first game of the series. That information is wildly valuable to people who like to gamble on Major League Baseball. In fact, they know once that information is released publicly, they have a good idea of what the rotation is going to be for the home plate umpires because they tend to rotate clockwise. But there is a period of time right now where that information is available, but not publicly. NBA referees have very clearly studied and established patterns of low-scoring games, road teams being more successful in games. There really is no limit to the types of information which are valuable to bettors. Ted Leonsis, who owns 7 professional sports franchises, including the Washington Wizards and Capitals, recently made a comment. I liken sports betting more to Wall Street. I don't believe it'll be considered a game of chance. I think it will be a game of skill. Just like you can be a day trader, you can be at Goldman Sachs making billion-dollar bets on companies. Leonsis does not like using the word gambling. He calls it gamification because, again, this information, there is so much information that is relevant to these types of wagering decisions. Information's king, and I don't need to read the slide. The Vice President of Business and Legal Affairs of the NFL noted that there is a price tag to this information. It is valuable, and as more money goes into it, the price tag goes up. Even with respect to game data, a Nielsen report that was recently issued estimates that the NFL could net $30 million per year in selling subscriptions to its advanced game data. The Major League Baseball Senior Vice President similarly noted that you're going to see an explosion in the exposure of athletes, and there's going to be a lot of temptation in these areas of inside information. What are sports doing about this? Well, the NFL has injury reporting. They have not changed those rules, even though the veracity of the reporting is highly suspect. Bill Belichick being a notorious example of somebody who is well known to play games with injury reporting. Major League Baseball has already announced that it is not going to even address what it does with its injury reports, lineup decisions, and umpiring decisions until sometime in 2019. The NCAA is still studying the idea of a national injury report. The NHL has no policies whatsoever with respect to transparency of information. And the NBA has very basic injury and availability reporting like the NFL. Again, simply the probable, questionable, et cetera. And it's only due by 5 p.m. the day before a game. So again, there is a massive opportunity here for information that is not in the public domain to be very, very valuable to people placing what are now legal sports wagers. The head bookmaker at Westgate, in talking about the LeBron James situation during the NBA Finals this past spring, made very clear that had it been known that LeBron James had a broken hand, LeBron James would not have been available in what are called prop bets, which are a category of proposition bets that are unique to certain players. Like, for example, you could bet whether or not LeBron James is going to score more than 30 points. They would have taken LeBron off of any proposition bet, and he believed the lines on the games themselves most likely would have been changed to some degree. Now, the people that follow sports know the Warriors were a massive favorite, but you have the chief odds maker there stating that line likely would have changed had it been known that LeBron had a broken hand. And there certainly were people that knew that LeBron had a broken hand. One thing that some of the leagues are doing is pushing regulators to require notice of suspect gambling patterns. And this all relates again to employers in the sense that there is a lot of opportunity, and we're focusing right now on athletes and leagues, but we'll talk a little bit in a minute about how this is going to translate to a whole host of employers. Most observers educated in this area are predicting it is a matter of time when, not if, there is going to be a scandal involving sports wagering as a result of the expanding legalization of this. And a lot of people are predicting it's likely to be in colleges, given the susceptibility of college students to these sorts of financial pressures and their relative lack of maturity. Now forget students. A Troy University study recently found that 8% of Division I trainers knew of a trainer on their own staff who was contacted by an outside source looking for relevant information. 8.5% knew of such a trainer at another school. 2% responded for themselves that they believed that they unwittingly provided inside information to an outside source at some point in the last year. And 72% admitted to having engaged in gambling in the prior year, 15% of them on sports games. A 2016 NCAA survey of 22,000 athletes found that 25% of all male NCAA athletes had violated rules relating gambling in the prior year, and 13% of them had made in-game bets. So again, this speaks to the breadth of this situation. And we're all familiar with point shaving scandals. There's a long list of them. University of Toledo, Arizona State, Boston College football, NBA referees. FIFA has estimated that $15 billion has been made by organized crime in match fixing scandals. But there have also been information scandals. In 1994, a notorious shady bookmaker named John the Bookmaker gave money to a cricket player for information relating to field and weather conditions. In 2008, a rugby player made more than $100,000 wagering on the top tacklers in the game and yardage statistics in the game. In October of last year, an Australian rugby player, or multiple players, were charged with providing information about injuries and lineup decisions about the Manly Seal Eagles to gamblers in exchange for drugs, prostitutes, and gambling debt forgiveness. It's gone so far as to affect youth gambling. Apparently, for some strange reason, you can legally wager on youth games in Australia, and the recruiter of a youth national team in Australia was found to have passed information about key players being arrested, and the gambler made a killing betting on games using that information. Closer to home, there was a mild scandal. I don't think it was very widely delved into, where an employee of DraftKings, who had been found to inadvertently release some information about wagering patterns during that same week, won $350,000 participating in the related FanDuel's fantasy contest, daily fantasy contests. The risks are even greater when you're talking about sports that draw less scrutiny, such as women's tennis matches going on in Australia this morning that Mike could have betted, or youth sports, or minor league baseball. All of these things are fair game for gambling now. The opportunities are also expanded by the fact that you can now have these in-game wagers where people can actually bet on changing lines during the course of the game. So right off the bat, we know that teams and schools are employers that need to worry about this. I'm now going to turn it over to Jessica Pearl, who's going to talk about some issues unique to healthcare providers, and then we'll come back and talk about how employers generally want to deal with these sorts of issues.
Thank you, Patrick. I think when we all initially started discussing this law and kind of what it meant, we of course identified exactly to whom the law directly applies. But then, as we kind of sat there, we started brainstorming, well, who else would be implicated from a practical perspective? And the healthcare industry was one of the first we thought of. So it's interesting for me as a healthcare attorney sitting during a gaming webinar and giving some education on it. But the more and more we thought about it and the downstream impact, the more we said, wow, this is something that we really need to talk about. So I think this is the formula. You have illegal sports betting. You have access to sensitive health information that could be used for a betting advantage, and it's pretty lucrative. So there are lots of relationships between sports and healthcare. You see a number of teams sponsored by, large healthcare systems throughout the state of New Jersey, and it creates essentially a perfect storm for employees or others to have some unauthorized access to medical records to gain an advantage on betting. So the scenario is athletes are hurt, they receive treatment from physicians at hospitals that may not be, directly covered by the law because they're not per se the team doctor, but they're or not, necessarily directly affiliated with the team or university, but still the athlete is there, the athlete is getting treatment, there's an injury that has a potential impact. So this access to or availability of information that can be used to bet at an advantage can create a very vulnerable situation for healthcare entities. It's very concerning. If you step back for a second, and think across the country, the temptation to, have unauthorized access to medical records has always been there. We see this, as a recurring problem for Los Angeles area hospitals with celebrity breaches of celebrity patient records. UCLA Health System, for example, found itself at the center of a scandal dating back to 2008 involving workers who were snooping into the medical records of commonly known celebrities, Britney Spears, Farrah Fawcett, Maria Shriver. One employee was convicted of actually selling the celebrity medical information to the National Enquirer. UCLA agreed to pay a heavy fine of almost $1 million as part of the settlement with federal regulators. This is, of course, a HIPAA concern. It's unauthorized access to medical records. Again, where is the lucrative information? If we're focusing back on gaming and sports betting, it's in the electronic medical records. We're all at computers, and we are in the age of having all of this information available at our fingertips. The question is, are you authorized to have the access or not? Again, we have a scenario with an employee that has access to the medical records, sees a sports player injured, hears something, knows so-and-so is coming in to seek treatment from the hospital. So the employee naturally, is inquisitive. Whether they initially have the intention of placing a bet with the information is of no consequence because they're inappropriately accessing the record if they don't need it for direct care needs or other authorized access under HIPAA. So they can either keep the information, use the information, share the information. It's endless. So it's not only an issue up front, but the downstream of do we get into selling the information to other people in addition to placing the bet. So, Patrick brought up, the concept of injury reports. I think it's an important distinction. We're not talking about injury reports that you get usually at 12 o'clock on ESPN so you can set your fantasy team. We're talking about employees or other folks at, hospitals or covered entities that have access to medical records and access, those medical records inappropriately in an unauthorized manner. Again, when we're talking about HIPAA, we're talking about covered entities. Are you a covered entity? You should know. But generally, the information that are on injury reports are collectively bargained and they're voluntarily provided. So that's why, when you time the information is important, as both Patrick and Michael have talked about before. Again, I'm even concerned, when we talk about downstream impacts and the reach of this, I'm even concerned with the employees who actually have access to the information with authorization. So you're getting it in the regular course of conducting your business, but then you still use it to bet, or you're giving it to other folks who also bet. So you're not necessarily violating the gaming law, but you're creating a business reality for your employer that is difficult to deal with if it's publicized. We also wanted to raise an interesting side note on this issue of, I think some folks come back and say, well, professional sports players, and we're just looking professionally for a second, they're employees. So there's been a historic tension between whether the medical records of athletes are actually employment records, and should they have the same privacy rights that the rest of us have with respect to our medical records. That, I'm not a professional athlete, I'm only a lawyer, so nobody cares if I got, if I had knee surgery a couple of years ago, which I did not. So this has actually been discussed. This was early on in the HIPAA process. The United States Health and Human Services Department, the agency that's responsible for enforcing HIPAA, considered this and they considered a comment to the proposed HIPAA regulations that suggested that health information related to professional athletes should qualify as an employment record, right, and not have these privacy, and shouldn't be considered protected health information. But HHS was very clear, as you can see from the quote that's on the slide, in responding that professional athletes have the same HIPAA rights as any other individual. So they didn't like the suggestion that there was any sort of category of individual that had less right to the privacy of their medical records, notwithstanding the fact that they were professional athletes. So it's an interesting side note when we talk about, what information should be private and the values that we have. So also wanted to give an example of, before the gaming law, there are a few examples of breaches of athlete medical information. I think we all know the Jason Pierre-Paul example. This was an issue because I believe some of the reporting on ESPN had like screenshots of their screen or a medical record, and this was a huge issue when the story broke and in the reporting of it. Reporters are not covered by HIPAA, but there had to be at some point a breach of the medical record, right, for a covered entity that was treating him or otherwise, that then provided to or had some sort of access issue, and ESPN had access to the information. So in that situation, there were 2 hospital workers, a clinical staff nurse, and a secretary were fired, after an investigation, and they were found to have unauthorized access to that medical record. Richard Collier, Jacksonville Jaguar, 20 hospital employees were fired for unauthorized access of his medical records. He was shot while sitting in his car and sadly paralyzed. But again, this shows that folks are interested, not only on a celebrity level, not only generally, athletes are celebrities as well, but now you're adding a financial incentive for this access from a gaming perspective for your winnings, and then you're sharing it with folks. This is a really concerning issue that hospital or covered entity employers need to think about. So when Patrick was talking about colleges and universities before as well, we think about the college athlete, right? We think about the team, we think about the coaches, the NCAA, we think of all of that. But colleges and universities could have HIPAA issues in addition from the direct prohibitions under the law. You have to ask yourself, are we self-insured? Do we have a student health center where you're treating folks, including your student athletes, right? So that's another consideration. Do you have a relationship with an affiliated medical center where your student athletes are also being treated? So, the point of this slide is not only do colleges and universities have to pay attention to the gaming law, right, and the direct regulation and impact of that law on their student athletes and others that are named in the law, but are there also other institutional concerns that we have that could implicate other obligations, other PR issues? I know Pat's going to talk in a second more about from the employer perspective on a broad scope, but think internally, are we a unique situation that we could be a hybrid organization? Could we have different vulnerabilities? So both in the annual compliance training and different audits that may go on in your institution from a security perspective, this is something that merits being brought up and merits being discussed on the broad level. So with that, I'll hand the presentation back over to Patrick.
Thanks, Jessica. So what do employers need to do? And before we talk about some of these employers that have employees with maybe unanticipated access, as an initial matter, every employer needs to carefully think about gambling policies in the workplace, simply because of the time, productivity, and morale issues we touched on earlier. But and we'll see an example of that type of policy. But beyond that, you start thinking about the various industries where it is very foreseeable that employees would have access to the type of information beyond the school, beyond the professional sports team, beyond the healthcare provider. Media organizations whose reporters or people, peripheral to reporters may hear about these sorts of stories in the context of their job. facilities employees. You know, the employees who are at an arena changing the court from ice to a basketball court that may just happen to be at the right place at the right time. But it is certainly foreseeable they're in that building. Obviously, gaming industry employees, hospitality employees. We talked about the example of the hotel clerk who gets involved in a discussion or happens to overhear something. People like us sitting in this room here, professional service providers who may represent clients with some relationship, if not an athlete, him or herself, to the team that might happen to have access to some information and discuss it. And any partner of any of those sorts of organizations, again, I think it's very foreseeable that those employees in a whole host of contexts would very foreseeably get access to the type of valuable inside information that we've been talking about. So policies. Well, certainly at the broadest level, we can talk about prohibiting gambling while at work or using company systems and resources while at work. What's an example of a policy? And I found this one online, just I was curious to see, you know, what sorts of generic policies were out there. And I sort of modified this from one, and I don't know that this is a great one, but this one acknowledges that some forms of gambling are legal, but then goes on to state that the company prohibits most forms of gambling. And that the company, in this case, may allow exceptions for sponsored events for a charitable or fundraising cause. So that's an example of sort of the broadest type of gambling prohibition that you'd want to have in your policies to make clear that employees are not allowed to gamble while at work, whether or not the gambling is legal, and they're not allowed to use company resources to do that. But you need to be careful about the exceptions here because, again, we've talked about this. I'm sure that every employer here or listening to this webinar has employees that have participated in some form of fantasy sports or March Madness pool while at work and while using company resources. So it's not as simple as saying we're going to ban all gambling if you want to have a consistent, clear policy that employees understand and that can be used as a predicate for discipline if employees violate it down the road. Something that you need to be very careful about and think about how you want to craft that sort of policy to have in your handbook. So we talked about the fact that you very likely have employees already violating this and ways to think about how to define gambling, how to define exceptions, and how this relates to your broader policies for employee use of company devices and resources. All very pertinent questions considering how much of a drag this activity could be for a lot of employees in the workplace. We can think about prohibitions on gambling on certain teams or events. Now, while this may not be something that's relevant to many employers, it's certainly something that employers in the media or team or school space should be thinking about, sort of consistent with the provision in the New Jersey law that prohibits apparently gambling on New Jersey colleges, but not professional teams in New Jersey. And, you know, really following a lot of our discussion here, most employers, and certainly that whole host of categories that we've talked about, where it is foreseeable that an employee could get access to this type of information, should be adopting some form of policy that prohibits the use or disclosure of inside information. And while no policy is going to stop any violation, that's not really the point. And you can liken this to, you know, the growth and now, you know, overwhelming prevalence of harassment policies that employers have, which not only serve to educate and deter conduct by employees, but also create defenses for employers in a case of a violation. And, you know, we're at a very early stage of this activity being legal, and I think it's important for employers to get in front of this and be proactive and think about adopting these sorts of policies. So we have an example on the slide, and you know, this particular slide, we don't need to go over it, but it's interesting to note that this definition of inside information, you know, comes from a policy position paper from the Gambling Commission of Great Britain that was just issued on August 30th of this year, August of 2018. And there is actually a sports betting intelligence unit in this gambling commission, which receives and investigates reports of misuse of information throughout the country, not just related to regulators, not just related to teams, but in all sorts of contexts where it could be involving a whole host of different employers. And in that position paper, the commission itself recommends that these sorts of provisions be included in policies where employees have, they just say relevant employees, but they don't really go into thinking about how widespread that exposure could be. The commission also recommends that this sort of prohibition be included in non-disclosure agreements. So even beyond general employment policies and manuals, if you're an employer with a real focus with certain employees who are very likely to be given access to this sorts of information, it makes a lot of sense to look at your non-disclosure agreements to specifically refer to this category of information.
I would note, Patrick, the UK's gambling market is very mature. They've been having this for quite some time, so that's really a leading indicator for where things could well go in the US now that legalization is expanding.
And you know, apropos of that, you know, in Australia, following one of those rugby scandals we talked about, that's what prompted Australia to pass a law flatly banning wagers based on inside information, which is something we don't have now, but I think, again, is very likely to come to fruition here as we see the inevitable scandals. We can think about policies that address inquiries employees receive for access to inside information. Remember that Troy University study we talked about, where trainers, you know, self-reported that they're getting inquiries from outside sources about relevant information. You know, again, particularly where employers, you know, touch on these areas, and frankly, I would argue any employer, it makes sense to incorporate in a gambling policy a provision which makes very clear that if you receive any contact from somebody outside the company addressing this sort of information, you were to report it to HR immediately. So those are the specific employment policies. We wanted to wrap up by touching on a few considerations for employers, not necessarily related to policies or manuals, but which are likewise very important. It is worth noting that employees with gambling addictions are not covered by the Americans with Disabilities Act. And there's one New Jersey decision addressing the law against discrimination. It's called DiPiano versus Atlantic County, which at least as of now seems to suggest that New Jersey, although in many ways the LAD is broader than federal laws, the LAD is being interpreted consistent with that, and that court ruled that a gambling addiction is not a protected disability. That doesn't mean, though, that employers shouldn't address education and compliance programs no different than they would with alcohol or drug addiction problems, including supervisors spotting those sorts of issues. You know, this is a productivity issue, it's a disciplinary issue, and it's something which we are really at the tip of the iceberg, you know, given the on-demand access that now all of our employees are going to have in New Jersey to access this activity at virtually any time. What's the smart action? You know, wrap this up. You know, again, consider all the ways in which your employees can not only gamble while at work, but potentially have access to this information, and be proactive on this. You know, get in touch with us, develop policies, you know, supplement your handbooks to specifically address this. This is going to be an issue. There's no question. It's not a question of when or if. It's just a question of when. So I think we're through. You know, we've gone just about an hour. If there's any questions, Vinny?
Yeah. So we realize it's 12 o'clock. I know a lot of people have 12 o'clock meetings, lunch they want to get to. By all means, if you have to go. All of you who registered for this will be receiving an email tomorrow with the full recording of today's presentation, so you don't have to feel like you missed out on anything. It'll also be on our YouTube later today at youtube.com/NJBIA. But for everyone else, I just want to give a couple of seconds for you guys to type in any questions you have. We have a couple here already. But while I'm stalling, I'd like to take a moment to remind you about the Handouts tab. We get a lot of questions from people about how to download the slides. So just open up the tab marked Handouts in your GoToWebinar panel, and the file is right there. You can also just wait until tomorrow, and they'll be emailed to you along with the video. So there's also the questions tab. If you have a question, type it in right there, and I'll make sure our guests answer it. And don't be shy. You've got 3 experts here, so make sure to take advantage of them. I can't tell you how many times I read the post-webinar evaluations and see someone disappointed that a relevant topic wasn't covered, or that like this thing was too broad or too narrow. If there's something you want to know relevant, ask the question. So anyway, with all of that out of the way, let's jump right into our first question that comes from John, who'd like to know, our employees participate in March Madness and fantasy sports. If we have a gaming policy, should we include those?
Well, I'll take that, and that's a difficult question. You know, if you're in a situation where your employees, you know, are doing this, even worse, where it's something which is company organized, you certainly want to incorporate that in a policy. You don't want to adopt a complete prohibition of gambling at work without referencing that if you intend to enforce it. The last place you want to be as an employer is have a broad policy which there are known exceptions to, which when you wind up disciplining somebody for one of the non-exceptions, they can point to, well, you didn't terminate Mike or Jessica, and they're playing fantasy football, 5 days a week. Why is that any different than me being on my DraftKings application? So you really do need to be very careful about drawing distinctions like we talked about if you're going to have flat prohibitions or how you implement them.
Okay, our next one comes from Bill, who would like to know, what can a healthcare employer do as initial steps to address these issues?
I'll field that one. I think if you're a covered entity, certainly this can be included as a topic for discussion in your annual compliance training, educate your staff on the potential for unauthorized access. You've faced similar situations in the past, but I think that with gaming law, the enactment of the gaming law, there's new potential. So I don't think you can go wrong with education and continued communication with your staff members. Again, similar to the general employment guidance that Patrick has given.
We have one here from Shannon who says, I'm a multi-state employer in New Jersey and other states that do not allow sports betting. Do I have to have the same policies across all locations?
Well, I think it makes sense to have, an overall policy that can acknowledge that, gambling is legal in some of our locations, not all. Certainly as it relates to what you can do in the workplace, and as it relates to the access to information. I mean, it's simple for, Pennsylvania employees, for example, can take a drive over to the bridge, or if they're on a sales call, can place a wager, while they're in New Jersey, and that information flows across the river, between Philadelphia and Camden or upstate in New York. I think it makes sense to have an overall policy, and given the ubiquity of, as more and more states come online, it really does make sense for employers to address this as an overall policy, even though there may be differences in state-to-state legality.
All right, I've got one more here, but keep them coming. So Jill asks, should colleges and universities look into policies related to student gambling? I feel like I already know the answer to that, but go ahead.
Well, I think you probably know the answer, Vinny, is I would say yes. And we spoke earlier about the NCAA obviously having regulations of their own. Those, are reach schools that participate in collegiate athletics and impose disciplinary action on student athletes or prospective student athletes for violations. But I think schools should take a more holistic approach, because obviously many students are not student athletes covered by the NCAA regs. Yet if a scandal were to brew, that school's reputation would really be on the line if, information was being shared in a dorm room and that's getting, texted to big bettors or, anything of that nature. And obviously schools want to protect themselves just like employers would. So I think colleges and universities should absolutely look at this matter, and a lot of the things we spoke about earlier are relevant to them as well.
Well, that looks like all the questions we have, so it's as good a time as any to bring things to a close. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that we hope you'll fill out. so we can understand how to best provide you important information in a webinar format. Our next webinar, Energy Market Intel and the Effects on New Jersey Businesses, will take place Wednesday, October 24th. So by all means, feel free to register for that one right on our website at njbia.org. So until next time, from Mike Collins, Patrick Doran, and Jessica Pearl, this is Vinny Civitello thanking you for being with us this morning and wishing you a good day.